So I have 6 general goals for today. The first thing I'll do out of politeness is to introduce myself and the nature of my scholarship. Then I'm going to familiarize you with the case study of concern today, the US court case of Naruto v. Slater. In order to introduce you to the theoretical framework of my analysis, I will define my field of inquiry, rhetoric, and situate it within the context of law. In doing so, I will expand upon the rhetorical concept of the public screen by proposing my concept of the litigious event as a matter of concern for animal law. In so doing, I attempt to define Naruto v. Slater as a litigious event concerned with the boundaries of personhood, as opposed to simply another quote-unquote crazy PETA stunt. In so doing, I will infer the potential and the pitfalls of litigious events for U.S. animal law scholarship and practice, and potentially international animal law scholarship and legal practice. So briefly, who am I? Well, you've already heard my bio, so I'll be brief. My field is in communication, more specifically in rhetoric, even more specifically in environmental rhetoric. My work is very much at the intersection of rhetoric, critical cultural studies, and environmental communication. And my specific research interest lies in the rhetoric, or I should probably say rhetorics, of animal rights, animal liberation, and animal law and policy. As somebody who resides within the United States of America, I do take the United States as my geographic focus. Broadly, however, I have a global concern with anti-speciesism and total liberation in law and life. Ergo, my scholarship is not merely descriptive, it is prescriptive, wherein I attempt to, in my scholarship, not only describe phenomena, but propose strategies and tactics for the furtherance of animal rights and liberation. So what happens when you give a macaw a camera? Well, that is the topic of today's lecture, and that was the topic of the case of Naruto v. Slater. In 2008, David Slater, a professional nature photographer, went into the Sulawesi jungles of Indonesia in order to take nature photographs of the critically endangered Celebes macaw. Slater was experienced with taking photos of non-human animals. And so his strategy was to follow a group of approximately 25 macaws. He practiced what he called, monkey etiquette, which is to say a series of interpersonal cross-species practices to build rapport with the macaws he was following in order to make them feel comfortable with his presence. Once he felt that the group of 25 macaws were comfortable with his presence, he set his camera on a tripod with a wide-angle lens, stepped back, and left the macaws to play with his camera. To the surprise of many people who had never known macaws to play with cameras, but not really to Slater, who had anticipated this response, the macaws played with the camera, pressed buttons, and ended up taking what are broadly known as the first monkey selfies. Many of the photos that I have shared with you are the viral photos in question. And in fact, the first photo, the top left photo, has been shared well over 50 million times online. So who cares? They're just monkey selfies. Well, in fact, when we take a look at monkey selfies through the perspective of the US legal system, a couple legal conundrums emerged. The first question was, did David Slater have the copyright to the photos taken by these macaws? Well, this question emerged after Slater licensed some of these images to the Caters News Agency in Great Britain. British news outlets such as the Telegraph and the Daily Mail shared these photographs, disseminated them widely to the extent that enough shares happened that we could really say that the photographs went viral. The image on your left is one of many, many, many news articles that were basically fluff pieces, adorable pieces that shared these macaws and their selfies. This was what Slater wanted. This was why he licensed the photos. This was a way for him to try to not only shed light on the endangered macaw, but also to profit off of his professional photography. But in 2011, something significant happened. Wikimedia uploaded 2 of these photos to the Wikimedia Commons under a free content license, which is more colloquially known as public domain, an image that can be shared freely because nobody has the copyright. Well, Slater took issue with this because those were his photos, the photos that he was attempting to profit off of as a professional photographer. He requested that Wikimedia remove those photos, but the Wikimedia editors said absolutely not. Their contention was there was no human author to these photos. The macaws had taken the photos, not Slater. Ergo, Slater had no legal right, no legal copyright to these photos. Slater contended the opposite. Quote, "You can look at it like this. The monkey was my assistant, and therefore I was the artist behind the image, and I allowed my assistant to press the button." This became such a novel legal dispute that eventually the US government weighed in to the extent that they actually referenced this case in the 3rd edition in the Compendium of US Copyright Office Practices, saying, quote, "The US Copyright Office will register an original work of authorship provided that the work was created by a human being. The office will not register works produced by nature, animals, or plants." To this day, the 2 photos that were uploaded to the Wikimedia Commons are still there. Slater has contended, quote, "It's killing my business." And to this day, he has lost well over 10,000 Great British pounds in income. But more pertinent to our discussion today was the second legal conundrum that emerged. If Slater did not have the copyright to this photo because he did not take the photo, is it possible that the macaws themselves had the copyright to these photos? And that was contended when People for the Ethical Treatment of Animals, a well-known global animal rights organization, in 2015 entered this legal fray. And they actually sued David Slater on behalf of the specific macaw whose photos were uploaded to the Wikimedia Commons, a macaw that they dubbed Naruto. Now, PETA used the next friend status in the US legal system in order to sue, because obviously they could not claim that they themselves were damaged by copyright infringement, but were basically suing as an interested party on behalf of Naruto, this macaw. Their argument was that Naruto was the author and thus the copyright holder of these viral monkey selfies. Naruto, quote, "saw himself in the reflection of the lens, drew the connection between pressing the shutter release and the change in his reflection, and made different facial expressions while pressing the shutter release." Obviously, damages in a civil suit such as this come in the form of monetary compensation. As Naruto, the macaw, would have little use for monetary compensation himself, what PETA proposed was that Slater should donate profits gained from his selfies to macaw conservation organizations, with no profits going to PETA itself. When PETA posted on this case to their official blog, they said, quote, "Our argument is simple. US copyright law doesn't prohibit an animal from owning a copyright. And since Naruto took the photo, he owns the copyright as any human would." Chief General Counsel Jeff Kerr of PETA Legal added that, quote, when science and technology advance, the law adapts. There is nothing in the Copyright Act limiting ownership based on species. PETA is asking simply for an interpretation of the act that acknowledges today's scientific consensus that macaque monkeys can create an original work. So, to the surprise of nobody familiar with the inherently speciesist anthropocentric nature of the US court system, this case resulted in an epic failure on PETA's part. In fact, one of the top US organizations concerned with the prevention of, quote, frivolous lawsuits, the US Chamber of Commerce's Institute for Legal Reform, called Naruto v. Slater, quote, one of the top 10 most ridiculous lawsuits of 2015. In Judge Oreck's initial 2016 decision on the case, the judge declared, quote, I'm not the person to weigh into this. This is an issue for the US Congress and the US president. If they think animals should have the right to copyright, they are free, I think, under the Constitution to do that. Naturally, PETA appealed this decision, but the Ninth Circuit appellate decision in 2018 concurred. We conclude that this monkey and all animals, since they are not human, lack statutory standing under the Copyright Act. However, in a footnote of this decision, the appellate court took it a step further, lambasting PETA, absolutely lambasting them for having the nerve to file this lawsuit in the first place. In fact, referring to PETA not as a next friend of Naruto, but in fact as a bad friend. Quote, we feel compelled to note that PETA's deficiencies in this regard go far beyond its failure to plead a significant relationship with Naruto. Indeed, if any such relationship exists, PETA appears to have failed to live up to the title of friend. The Ninth Circuit was so annoyed by this case, in fact, that the 2017 settlement that was reached between Slater and PETA in the interim between the initial 2016 decision and 2018 appellate decision, wherein Slater actually did agree to donate much of the profits of this photo to macaque conservation organizations, was essentially overruled by the appellate court. They were not interested in abiding by the terms of the independently reached settlement because of the extent to which they felt PETA was out of line by even thinking that perhaps Naruto could have copyright to his own selfies. To this day, no one holds the copyright. Slater's camera, Naruto's photo, but no one holds intellectual property legally in the United States over these selfies. So the case was an epic failure within the court. That being said, when we look at the out-of-court result, we can see this civil suit in terms of virality. This case is a colloquial, Googleable case on par with civil cases such as the McDonald's hot coffee lawsuit. If you just Google the name monkey selfie lawsuit, you will see Naruto's selfies plastered everywhere. Comments have been given on this case from formal legal organizations like the US Copyright Office, to tech blogs, to law schools, to famous podcasts such as This American Life, to vernacular, cutesy organizations such as knowyourmeme.com. This case gleaned international news coverage from US outlets like the New York Times, all the way to South Asian organizations such as India.com. Coverage of this case crossed the US American political spectrum, from conservative Fox News all the way to the far left international group, the Young Turks. And in this coverage, the question of Naruto's potential copyright holding was framed as an ongoing legal question, not only for people concerned with animal law and policy, but for those concerned with art law and policy, with artificial intelligence law and policy. At this moment, this is a case now frequently taught in US law schools as an interesting case that really shows the limits of intellectual property. So my overarching theses that I'm going to discuss here are fourfold. First, that PETA's seemingly pointless, failed, even frivolous lawsuit is none of those things, because it affords us a glimpse into a rhetorical phenomenon that I dub the litigious event. A litigious event involves a filing suit over what seems at first glance to be a legal lost cause due to the inherently oppressive structures of a formal anthropocentric courtroom system. Through the creation of a litigious event, however, I argue that the plaintiffs of this case in a lost cause is really only lost vis-a-vis the unlikelihood, although not the impossibility of, a formal legal decision going in their favor. But that lost cause can actually be found again within the court of public opinion, which is to say, public discussion of these cases outside the court of law through the stimulation and maintenance of viral public discussion. For instance, through the viral discussion of what constitutes a person under the law, what it means for a person to have intellectual property, and thus the potential for non-anthropocentric boundaries of personhood and its epistemic cousin, intellectual property. So to understand my thesis, of course, it's necessary to define my specialization, which is rhetorical studies. Now, I am aware that in past seminars, we have actually had scholars in this room delve into rhetorical theory. So I will be brief as I define what actually is rhetoric. Rhetoric is largely a branch of communication studies concerned with the humanistic study of argumentation, persuasion, and how attitudinal and behavioral change occur. It is an interdisciplinary branch of humanistic inquiry concerned with discourse, ideology, power, argumentation, and persuasion, typically housed in the US in departments of English or communication studies. There have been multiple definitions of rhetoric across time, space, and place. The most famous, of course, being Aristotle's famous quote that rhetoric is, quote, the faculty of discovering in any particular case all of the available means of persuasion. And I'd like to call attention to that, available means of persuasion. In any given case, there is not a singular way to persuade, but a series of possible ways to invoke attitudinal and behavioral change. I thus extend my own definition of rhetoric, which is to say the act, study, and inevitability of persuasion in everyday life. This persuasion can be explicitly verbal, it could be nonverbal, it can be intentional, and it can be wholly unintentional. It can be human, and it can most certainly be more than human. So, fundamental to rhetorical studies of law and civic life is this notion of the public sphere, which is a concept proposed by critical theorist and Frankfurt School aficionado Jürgen Habermas. This was initially proposed in his book, The Structural Transformation of the Public Sphere in 1962, which was an intellectual history of Western democratic thought and practice, with an emphasis on a notion called deliberative democracy, a theory of democratic practice that is reliant on communication practices. The public sphere, according to Habermas, is proposed as a place that exists between private individuals and government authorities, in which citizens meet and engage in debates about public matters of social import. Now, for Habermas writing in 62, this emphasis was very much on face-to-face, in-person, non-mediated discussions. Exemplars included, for example, the London coffee shop or the French salon. It was, for Habermas, an alternative to the spectator cultures associated with top-down, king-god, governmental systems such as feudalism, and for Habermas was very critical of mass media, which for Habermas was a potential threat to face-to-face public discussion due to the potential of the return to a spectator culture, which would prevent face-to-face inquiry. As we can see through this diagram, the notion that a public sphere could serve as a middle ground between society and state relied on the assumption that there was some sort of civic public through which public discussion could result in the formation of public opinion. Public opinion, once formed, could constitute what in democracy would be known as a public consensus. And if this is discussed accordingly, public consensus would, in theory, mediate the power of the state so that policy proposed by the state would be in the service of and not antithetical to the public good. And this is what constitutes principles of publicness. Thus, Habermas defines the public sphere as a sphere mediating between state and society, a sphere in which the public, as the vehicle of public opinion, is formed, and there corresponds the principles of publicness. But there have been a series of important critiques of the public sphere, not least the idea that, like many theories of ideal democratic societies, a communicative theory of democracy is reliant upon an ideal speech situation, wherein we assume everyone has equal access to this sphere. There have also been critiques of this idea that there is a singular public, when in fact, if we assume there is unequal access to spheres, there are different lived experiences and power dynamics among individuals that could prevent this access, different ideologies that could prevent the bracketing of differential lived experiences in the service of a singular public good. This would result not in a singular public, but publics, or in fact, counterpublics, which frequently advocate against dominant hegemonic ideologies that could, in fact, if taken seriously, totally upend prototypical assumptions about what constitutes proper political power dynamics. And of course, since Habermas was inherently critical of mass media, when we look at public sphere in 2022, the technophobia identified would seem to be outdated. How does one account for this emphasis on face-to-face public discussion when I'm talking to you through Zoom right now? Which is why I rely on a theory of rhetoric and public sphere that explodes the concept of the public sphere entirely. A model of publicness, and counterpublics reliant on the dissemination of communication as done through visual cultures, screen-based cultures, hyper-mediated cultures, which put simply can be defined as the public screen. According to Kevin DeLuca and Jennifer Peoples, who initially proposed this concept of the public screen, Habermas's idea of the public sphere is long since dead, and that's if it ever even existed at all. In 2022, there has been unarguably a shift away from whatever model of that London coffee shop Habermas was talking about to a very much visual, digital, glance-based, short attention span society, hyper-mediated through screens, to the extent that I am talking to you through a screen right now, showing you screens within screens. In this very slide, I am showing you a new screen, a live coverage of a protest that itself was probably then broadcast to YouTube and then rebroadcast from YouTube to another hyper-mediated channel. Under a public screen model of communication, the message is actually less important than the dissemination of that message, because the risk of communicative dissemination is lower than the risk of not communicating at all. So within a public screen theory of communication, The idea is not that corporatized mass media is a threat, but that counter publics who are typically not granted equal access to communicative platforms because their ideas are considered controversial, are able to actually harness the power of corporatized mass media platforms against themselves through using spectacular argumentation techniques, largely concerned with spectacular images. Arguments in this sense are not opposed to mere spectacle, but are composed utilizing spectacle. And this is done through what DeLuca and Peoples call the image event, a staged act of protest designed for mass media dissemination, where images serve as argumentative fragments, as mind bombs that are meant to explode public consciousness. The task of the audience who sees these images is to reassemble those fragments. But the task of the rhetor is to assist in this unruly screened environment where, due to the nature of virality, a message can be interpreted in so many different ways, rebroadcast in so many different ways, that while a counter public can ensure their message is disseminated, they can never really control the extent to which that virality is interpreted and reinterpreted and reinterpreted. So the public screen constitutes a very, very risky model of communication that is nonetheless a strategic point for counter publics to make sure that arguments that are often brushed to the sideline have a chance through spectacle to inspire public discussion of arguments that might otherwise be shoved to the side. For all of its controversy, for all of its questionable tactics, if there is one thing People for the Ethical Treatment of Animals does well, it is the use of image events in protest. Here is a quote that PETA likes to make sure those who follow it know. Quote, "We will do extraordinary things to get the word out about animal cruelty because it is sometimes necessary to shake people up in order to initiate discussion, debate, questioning of the status quo, and of course, action. Our gimmicks may sometimes seem silly, but they are vital if we are to reach the masses, initiate discussion, debate, questioning of the status quo, and of course, action." Now, these quotes are more typically associated with the more bombastic public protests associated with, for example, the images below, where people are known to dress up as sheep or dress up in nothing at all, or to create controversial video games or images of video games that shed light on the ideologies of animal cruelty, potentially even inherent in the video game series Pokemon. But something that is less often associated with the strategies and tactics of the PETA organization is their legal department, the goal of which is, quote, "to establish appropriate fundamental legal rights for animals and in their own right, and not in relation to their utility to human beings, and to, quote, shed a bright light into the dark corners of animal abuse wherever we find it." Despite the controversial nature of People for the Ethical Treatment of Animals in general, PETA's legal team actually won the 2017 Corporate Counsel Award for Best Legal Team. And this is actually the front page of Corporate Counsel with PETA's legal team on the front. In Kristen Rasmussen's article on PETA's legal team, quote, "It was the activist groups, attorneys, tough legal minds that have fundamentally shifted the animal law landscape in this country being the United States. For a group whose activist members are at times militant and provocative, its lawyers are down to earth and genial, motivated by a fierce love of all animals. It is undeniable that regardless of what you think of PETA's very controversial protest tactics, Their legal team has seen a series of successes, perhaps the most famous of which is the 1981 through 1991 case of the Silver Springs monkeys, a case of animal cruelty so profound that I hesitate to repeat the details of it here, but the result of which was the first time a scientific researcher was actually charged with cruelty to non-human animals. There are multiple suits against the now defunct US Ringling Circus. It has been largely credited with why the circus itself went under. They have been instrumental in defeats of US state level ag-gag laws. They have been part of convictions of meat industry workers for animal abuse, and through lawsuits have secured the release of well over 60 bears and 8 chimpanzees from US backyard and roadside zoos. So to understand Naruto v. Slater within the context of this public screen, we have to understand why the public screen itself and its digital nature is inherently related to this idea of capital L law. Because from a rhetorical perspective, law is not simply a set of rules, increasingly accurate and precise, that is, so long as profane politics can be kept out of the judicial equation. Wholly impartial, clearly based on neutral principles. Anybody interested in the anthropocentric, speciesist nature, racist, sexist, ableist nature of law knows this already. But what is often not considered is how law is a rhetorical culture wherein, quote, any group that is dissatisfied with the public arrangement may work to change either the legal system or the rhetorical culture in which it operates. Because legal actors, be they activists using the legal system or judges, lawyers themselves, must rely upon the common discourse of a culture to derive a vocabulary that will effectively depict such agents and actions and locate them in legally significant contexts. Law is to this extent not simply a top-down phenomena wherein expert judicial authorities invoke law and make sure that everyone below follows it. It is also a bottom-up process composed by professionals and laypersons. Because for anyone who is familiar with how things like established precedent are overturned, judges are not typically willing to engage in massive overturnings of precedent unless they feel that their reputation will not be destroyed if they do so, which is largely gleaned from shifts in public opinion. Put simply, legal practitioners influenced and are influenced by shift in public morality. Hegemonic moralities are then codified into texts, which we call the law. Intellectual property and copyright cases are inevitably involved in these notions of rhetoric, civic belonging, and public screens because intellectual property law represents majoritarian definitions of property and memory through rhetorical constructions of what Anjali Vats has called intellectual property citizenship. Digital images function within an economic dynamic in which users contribute content and other information of great value to technological systems over which, admittedly, they have very limited control. Inequitable intellectual property decisions result in identities that, quote, circulate as hypervisible or unseen parts of the cultural landscape. So to understand Naruto v. Slater through this perspective, I propose that it was not simply an image event, but a litigious event, which I define as a staged lawsuit designed for mass media dissemination. Studies of law under this theory I propose of the litigious event must also therefore include embodied, or in a screen-centered world, disembodied and resistive performative repertoires, which Isaac West has defined through legal agency, because legal agency is developed and practiced in ways that are not immediately apparent if we restrict ourselves to the immediate legal in-court moment. Under theories of a litigious event, therefore, I argue that intent to win a case is actually quite irrelevant, but intent to disseminate the case to mass public is. In so doing, what is a legal lost cause under a currently speciesist anthropocentric legal courtroom converts to a question not of, is this a lost cause, but should it be a lost cause outside the courtroom? Invocation of jurisprudential questions often forgotten about, e.g., notions of who should have standing, what is a person, and to what extent can someone without standing or without personhood own property? These can come from the bottom up, from the layperson on up to the lawyer, on up to the judge, and not merely top down. We can see merely through key quotes from journalists in high-profile US American and intellectual outlets how questions of standing, personhood, property, copyright, and intellectual property were planted through the viral dissemination of this monkey selfie lawsuit. Andrew Leonard of Salon is quoted as saying, the natural objection to Naruto is obvious. Monkeys are not people. But what if they are? Or more precisely, what if we aren't far from the day when monkeys finally win their right to have their day in court? David Kravitz of the famous tech outlet Ars Technica proposes, let's assume PETA is correct, that copyrights can be granted to animals. So why can't that owner be a monkey? Efrat Livni, of course, concurs that this case demonstrates that animals can make constitutional claims and thus may someday have rights like those of other legal people. Ira Glass, one of the most famous radio hosts in the United States of America, actually proposed in This American Life. Today, we have stories of people trying to completely erase the line between animal and human. But this was not said in a derogatory sense, but in a sense that proposed this was a story worth telling. A litigious event is, I propose, a trial for media, not a trial by media. Because as Wendy Atkins-Sayre and Ashley Stokes have proposed, PETA's strategies of rhetorical fracture rely on virality to generate interest in media coverage because it is far easier for activists to cultivate outrage through social media platforms that may, or of course may not, culminate in changes in corporate practice. PETA therefore purposefully and strategically appropriated these already viral selfies because PETA is not what made the selfies viral. Slater is what made the selfies viral. By filing a lawsuit that symbolically merged its own animal rights group with Naruto as his legal next friend. By legally gluing itself, hitching its wagon to an already viral image, I propose that PETA's legal team acquired what was basically a pre-packaged viral lawsuit concerned with intellectual property. This was not a slap suit, known as a strategic lawsuit against public participation, but rather a strategic lawsuit for public participation. Law, for any lawyer concerned with public legal cases, is not merely something that happens in a court outside of the public eye, but a practice of strategic advertising as a public relations campaign. According to Tracy Raymond, PETA's executive VP, quote, we could post the same footage and 1 million people will see it with 24 hours. People see the message, have a quick reaction, and post a comment on Facebook. We're there to continue to converse with them if need be. As rhetorician E. Cram explains, public trials give presence to the emergence of publics themselves acting as witnesses. And even if this coverage is negative, even mocking, negating a frame, according to cognitive linguist George Lakoff, necessarily activates that frame, which is to say, If I tell you right now, don't think of a macaw, every single one of you is going to think of a macaw, because despite me telling you not to, the way the brain works means you're going to. So even if I tell you monkeys don't have personhood, guess what? Your brain is now making the connection between personhood and non-human animals. This is a cognitive fact of how the human brain functions. We can also see how this case, through its virality, ended up serving as a platform for other animal rights litigators. Perhaps one of the lesser known but more strategic US animal rights organizations, the Non-Human Rights Project, offered a very public statement on the failure of Naruto v. Slater in the courts. And in fact, this statement was not praising PETA's case, but critiquing PETA's case. But their critique was based in very important jurisprudential arguments about how to achieve animal liberation. Because their critique was not, macaws should not have copyright, but rather, this was done backwards. You can't claim copyright before you have achieved legal personhood for animals. Legal personhood for animals must be achieved so that any case regarding intellectual property is intelligible. PETA was trying to gain personhood by claiming copyright, but in fact, according to Weiss, this is more applicable to current legal cases, like the case of Happy the Elephant, which the Non-Human Rights Project is currently litigating in an attempt to get Happy the Elephant freed from captivity and sent to a sanctuary on the grounds that Happy, through a writ of habeas corpus, should be freed from captivity and declared a legal person. If Happy took a selfie, the Non-Human Rights Project would not go for the intellectual property right first. They would go for personhood first, and most certainly not at the same time. This has to be strategic, one at a time. So even through this critique, arguments about the necessity of animal personhood in US law were advanced. I also argue that because of the virality of this case, international rulings of legal personhood or legal personhood adjacent decisions internationally became more intelligible to US publics. For example, landmark rulings on legal rights of nature in South Asia, South America, legal rights of dolphins, legal rights of a couple rhinos, legal rights of a couple Argentinian orangutans. These are cases that are intelligible if you already understand that these lawsuits have happened in the past and have been platforms for legitimate, not frivolous public discussion. So my argument is that this idea of the public litigious event has vast significance for animal law and policy scholars. First and foremost, because it advances scholarly jurisprudential conversations regarding how mediated viral screen culture has impacted and is impacted by the law and by lawsuits, where we can interpret law as spectacle as opposed to law versus spectacle. Because lawsuits as centers of public discussion and mainstays of public memory can occur despite and not necessarily due to their ultimate result. Practitioners, lawyers, activists can make use of the litigious event and its strategic and tactical potential for filing suits from a socially networked, not overly individually adversarial, private civil courtroom perspective. Because understanding law this way helps us understand that winning a suit is not necessarily the sole point of a case. Dissemination of that case also is, in so much as it can be utilized for carefully crafting public willingness to see a court change, to overturn precedent, to expand subjects of a precedent. Now, this is never guaranteed because of the uncontrollable nature of virality, because of the inherent anthropocentrism in public life. But the question must not always be to ask, is this suit winnable? But could this suit go viral for the right reasons? And if it does, how best can activists, lawyers, practitioners, scholars act to control this narrative for anti-speciesist advancement? And if we can, is the radical consciousness raising efforts of a litigious event in this particular case, in this particular moment, stimulated through virality, worth the risks, the uncontrollable risks of visual argument and virality? Because it is risky, much more risky than a professional legal case. So here are my closing thoughts. Naruto and the litigious event are entry points into broader legal and layperson questions about anthropocentric norms of property. Can non-human animals own property? Must non-human animals be declared persons before they can hold property, or could their ability to hold property afford them the status of persons in the future? Which ought to come first, personhood or property rights in animal jurisprudence? And how might these interests, as they relate to fields like artificial intelligence, digital art, etc., function as potential strategic allies in these conversations? We ought to consider the potential of litigious events for stimulating public interest and discussion pertaining to equitable distributions of justice between and across species lines. For anyone interested in reading the full article on this subject, I have provided the full citation. And if you would like to contact me with any further questions on this case, my email is here. I am going to stop sharing my screen now.